symbol of free, unrestricted access to the Strasbourg court. I would not see any value in saying you have to pay money, introducing some kind of court fee, or saying you can only lodge your application in one of the two official languages, French or English. I don't see why, for example, Slovenian people shouldn't be able to lodge an application in Slovenian. Okay, you would get less Slovenians going to Strasbourg if you said you must do it in English or French, but I don't think that is a good solution. It's a good symbol. Europe is perceived by most of the public as what goes on in Brussels, grey-suited bureaucrats. There is this famous democratic deficit that is associated with European institutions. Here you have a procedure that is open to ordinary people. They can apply in their own language. They don't have to pay. They don't have to get a lawyer. They can write it out in their own handwriting. And every once in a while, it goes all the way, and the citizen wins a famous victory against his or her country. And sometimes even the law is changed. It isn't just the individual gets paid a packet of money, but sometimes the system changes. So I would keep the unrestricted access as it is. But you need a much stricter and a much lighter filtering mechanism for looking when this stuff, you should go into the mailroom of the Strasbourg court. Letters arrive, about 1,000 letters, sometimes up to 2,000 letters arrive every day in 40 different languages. There's an army of people dealing with this stuff. They've even introduced barcoding, a bit like in hypermarkets, where an applicant gets a whole sheet of labels, which they have to stick on the correspondence afterwards, so that when the letter comes in, you just stick it at the screen and you can immediately see what the case is about and who is dealing with it, whether you read the language of the letter or not. You need some way of filtering out of that mass of stuff coming in the few cases that really do raise a serious, arguable case of human rights violation that merits being examined on an international level. And I would do this, first of all, not with a new or changed admissibility condition. Okay? No new admissibility condition. If you remember, the new one that was introduced in protocol number 14 has proved to be totally useless. And that could have been predicted, and we did at the time, but we were simply not, that's to say the court and the registry, we were simply not listened to by the government, who gave in to very strident lobbying by non-governmental organisations. All Amnesty and all the rest of them banging on the table saying you should not let money restrict the access of the individual must have this guarantee, that guarantee, and the other guarantee. And the governments listened to this, and they introduced this horribly complicated admissibility criterion, which, as I said, has been applied in less than 1% of admissibility cases since it came into force. So what I would suggest is a pre-admissibility condition. In other words, before you even look at whether domestic remedies have been exhausted, whether the 6-month rule has been respected, whether the case law shows that this is not the kind of case that is dealt with, or which is well-founded. Before you even get to look at admissibility, there should be the question put, does this application raise a substantial human rights issue under the Convention? Even assuming the applicant is absolutely right in everything he or she says, is it worth looking at the case? and it should be a simple yes or no, no reasons given, just yes or no, something that can be done on a glance, so that it doesn't take much time or much resources to do. Don't forget, as I said, there are 50,000 applications, well no, it was 61,000 in 2010, it's probably going to be 65,000 in 2011, 70,000, 80. This is not a criterion that I have invented personally. It was put forward in a report by the so-called evaluation group in 2002. This was the President of the Court, the Deputy Secretary General of the Council of Europe, and the Irish Ambassador, who at the time was the chairman of the Committee of Ministers Committee on Human Rights. So you had a representative of the governments, representative of the Council of Europe administration, and a representative of the court. And this group, in a report, recommended that there be this criterion. Is there a substantial issue under the convention? Secondly, this process of filtering out the vast mass of cases that raise no issue that will in any way contribute to raising the level of human rights protection, either in the country concerned or in Europe as a whole, that should be operated by lower level judges. In other words, not by the senior constitutional court type judges who examine the 100 or so cases that do raise a real issue. People like Mr. Yambrecht used to be. The ones who deal with the real cases. It should be lower level judges who do that work, perhaps with other responsibilities, say the routine cases. And secondly, I think what is called just satisfaction, that's the award of financial compensation, should be repatriated to the national system. It should not be dealt with by the Strasbourg court. There's a vast number of cases that are lodged solely in order to get money, for no other reason. I remember the first Russian case that was ever taken to judgment. The applicant phoned up on the morning the judgment was delivered and was told, yes, the court has found a violation of the convention in your case. I think it was concerned with non-execution of judgment, a civil judgment, awarding damages against a public administration, and public administration, like a lot of Russian public administrations and Greek ones as well, simply refused to execute the national judgment. We don't execute judgments we don't like. So the court found a violation, and the case lawyer said, well, would you like me to read you out the resume of the reasoning that was given? We have that in a press release. And the answer was, no, I'm not interested in that. How much money did I get? That was the only question that interested the applicant. When we had thousands of cases alleging unreasonable length of civil proceedings in Italy, the bar associations throughout Italy had printed forms which their members, the lawyers, gave to clients every time they came in with a civil claim. You have a dispute between two neighbours about a dividing line between two orchards. Right? The line taken by the Italian bar associations was that they would say to their client, okay, we will start proceedings against your neighbour, but you won't get a decision for 10, maybe 15 years. But fill in this form, and after 5 years we can get money for you from the European Court of Human Rights. It became the lodging of applications in Strasbourg became a kind of industry for Italian lawyers. I think it's time wasting. Having an international court, the European Court of Human Rights, operating as a mercantile small claims court for a multitude of individual cases that contribute nothing to the level of human rights protection in Europe. Or take Northern Cyprus. Remember I mentioned the Loisidou case. The result of that case is that there are now over 1,000, perhaps almost 2,000 cases lodged by Greek Cypriots in the south claiming full financial compensation for the property that they have lost in the north. And some of these are businesses, hotels or restaurants, and they are claiming damages for the loss of profits since 1974. This involves, for each case, a kind of actuarial study. What were the profits before 1974? What are the likely profits after 74? And you can imagine 2,000 cases, the time that it would take to properly calculate the financial compensation in those cases. But I think there should only exceptionally in Strasbourg be awarded financial compensation. Secondly, there should be a kind of supreme European Court of Human Rights with reduced membership. At the moment there are 47 judges, one for each state. There is a judge for San Marino, there is a judge for Liechtenstein, there is a judge for Monaco, there is a judge for Andorra, and they're all there drawing their full salaries, dealing with cases. I would suggest that you have a Supreme Court of, say, 15 to 20 judges. Each state should have a junior judge, right, sitting on the filtering European Court of Human Rights, but the court that deals with the cases of principle and that creates the case law should be reduced membership. It should have jurisdiction for the important cases, including admissibility as well as merits, and maybe it should be semi-permanent. That's to say, the judges, as on the old court, would come to Strasbourg, say, once a month. They would maintain contact with their member state. The old court, up until 1998, dealt with about 100 cases a year, with a hearing in each case. To justify, to maintain independence, I also think that the judges could be nominated by national supreme and constitutional courts to ensure that they are properly independent, and that for the smaller states there would be a system of rotation, a bit like there is on the Luxembourg court for advocates general. So that briefly is the institutional story of the court in Strasbourg. It's in a lot of difficulty. It could be that there will be proposals put on the table to do something, I don't know. My own government, the United Kingdom, which will be assuming the chairmanship of the Committee of Ministers in November of this year, have indicated that they might think of proposing some gross simplification of the system in order to prevent the growing backlog from spiraling out of control. I haven't said anything about the case law, but of course, or about the consequences of the accession of the European Union to the Convention, which is another interesting topic. But if we're going to have a question and answer session, don't feel restricted to the rather narrow institutional theme that I chose. You can put questions on any aspect of the Strasbourg Court.
Thank you very much. Thank you very much for this introduction. I think it was really comprehensive. It gave us a very good insight into how basically the court evolved, how we got here, where we presently are. You demonstrated that the situation is pretty complex. There are many problems that need to be addressed, but you didn't stop just at this point, you also offered some very clear and very interesting solutions. As I was listening to your talk, I was thinking to myself, how could we make sense of what's actually happening these days, in these last years, to judiciary in Europe? Because what you described, what's happening at the level of the European Court of Human Rights, almost, if not the same, very analogous things are happening at the national level. If you asked our constitutional court justices, many of those would be saying, would be sort of developing the same narrative. At the same time, when you would ask the people, those who claim their rights, who are the applicants, they would never, okay, I shouldn't say hate, but they would never criticize courts more. And yet, we have this, on the one hand side, we have this huge race with these applications to the courts. At the same time, we have this huge criticism and actually disbelief in the courts. And maybe we should just describe the situation as a sort of a European judicial malaise. And since we have also Professor Jambrecht today with us, and before I open the floor for your questions, there will be enough time, maybe I should ask Professor Jambrecht, because I know you've written something also about the problems the Slovenian Constitutional Court is facing, and the way they try to limit their caseload by cutting to a great extent the constitutional complaint, also cutting to a great extent the abstract challenges to the constitutionality. What would you say, as part of your experience? You were president of the Constitutional Court of Slovenia. This court started also with no cases, basically, and then ended up being a victim of its own success. What would be your take on this European judicial malaise, if we can call it like that?
Well, let me stand up because my voice is a little bit weaker these days, so you can hear me a little bit better. But the straightforward answer to your question does not really apply to my experience, because we did belong to a happy generation of Constitutional Court judges when we had 100 or 200 cases a year, which we could master and process, not I would say in an easy way, but we really did not feel burdened by the vast number of cases. And also, while we were serving under President Justice Rolf Riesda together with Paul, also we were not burdened with this kind of huge number of cases. That was a court, European court, in the 90s where and when the chairman of the court, president of the court, actually presided over all cases. And Rolf Riesda, the Norwegian judge originally, who was president of the court even after his 80s, the rule of 70s of the retirement for the European Court did not apply to him. They said, well, it applies only to those septuagenarians and not to octogenarians. But he could lead, he could direct the judges in each of the cases that were dealt with by the court. So actually, I don't have this kind of experiences. Although nowadays, listening to what Mr. Mahoney told us very vividly, and listening to the Constitutional Court judges burdened by their cases, of course, somebody thinks that there is something very wrong with this mechanism, which is overflown by thousands and even hundreds of thousands of cases, as it is the case with the European Court in Strasbourg. Anyway, whenever we are discussing these kind of issues, it's a long shadow behind us that we always as judges think of it, and that is the shadow of the US Supreme Court. Of course, that's the main yardstick to understand these two kinds of models. The democratic model of access to a court, when everybody has the right to a court and that his case be dealt with on the merits by the court. And then you have this, as I said, long shadow, the unique example of US Supreme Court, and also I think of the British Supreme Court of the law lords, where there is another experience. And I have to tell you, let's say, from a practical experience, in '95, I was on invitation of US government visiting the US court, Supreme Court, and actually I had a privilege. It was, in retrospect, really a very great personal privilege to have a discussion, personal discussion with Justice Scalia for a couple of hours. The 9 US Supreme Court justices really are members of a most powerful court in the world. They are excellent professionals, and they don't have time. So I was really surprised for the expenditure of a couple of hours to spend with Justice Scalia, and then we discussed in person in his office about the number of cases they deal with, and I'll tell you a couple of ideas that I remember vividly from the discussion. Now, Justice Scalia told me that he cannot imagine that a court composed of 9 judges can deal seriously with more than 100 cases a year. Now, you have here is just 100,000 cases or more. No, he straightforwardly told me, no, we are unable to deal with seriously with more than 100 cases a year. Although the US Supreme Court is also overburdened with the inflow of thousands and thousands of cases, but they don't accept them, and they don't deal with them on merit. And Justice Scalia told me what they are doing with those thousands and thousands of cases. Now, each of the 9 US Supreme Court judges has actually an office composed of 5 to 7 assistants, legal assistants, which he picks up himself or herself among the best Harvard, Yale, law school graduates. So they work for him in their offices, in the Supreme Court building. And they sift, they select cases on a weekly basis. So a judge has weekly sessions with his assistants, and they pick up cases which represent a serious legal issue of the US constitutional legal system. Very same criteria of selection that Mr. Mahoney told us he is trying to advocate for the European Court in Strasbourg. So everybody has access to US Supreme Court, but very meager chance that his case would be dealt with on the merits. Only cases which deal with an important legal issue are accepted by the court. Now, and here is the main point that I would like to raise. There are 2 models and 2 philosophies and 2 strategies. One is a strategy of a court which tries to solve, to decide each case on its merits, and gives on a book in abstract theoretical terms everybody residing in one of the Council of Europe countries a fair chance to send his petition to the court, and that the application will be accepted. Now, in United States, a citizen of the United States does not have this kind of chance. The court is an aristocratic, elitist court which on its own discretion, self-imposed discretion, there is no constitutional clause or legal clause that allows the US court to do that. They did it by their own decision and practice. Now, what is the effect of this kind of elitist, aristocratic position towards citizens and their petitions? The US court is actually a legislator. He doesn't, his ambition is not to solve individual cases, to help, to assist individuals in solving their problems, but to help other courts in the United States to define a national legal philosophy. So the US court produces not judgments, it does produce judgments on merits, but on a very selective basis, those judgments that in the view of the court and its judges define legal philosophy for the rest of judicial system in the United States. And they think that they can do it by 100 well-judged, well-argued cases a year. And I'm sure that Mr. Mahoney is speaking about this kind of philosophy, most likely, with this other Supreme Court of Europe, the Council of Europe, composed of 15 judges or more. Although I would disagree with you, Paul, when you say that those 15 judges would decide on the merits on the cases, but junior judges or assistants would decide on acceptability of the cases. In my view, acceptability is, in such a case, such a complicated and really important issue that it may be dealt with only in a way similar that Justice Scalia told me, namely on a closed session of a judge, of a justice of the court with his close professional legal consultants. So it's probably a product of a very well-argued decision-making process on which cases are worthwhile to be picked out of 1,000 cases to be dealt with and to be included into this docket of 100 cases a year. Well, I should stop here.
You have the right to come back and to react to respond to his question, if you wish so.
Well, on various points, I would say, firstly, in relation to your introductory comment, it's not only a European malaise. The former president of the Strasbourg court, Wildhaber, the Swiss judge, has just published an article arguing for more or less the same approach, and he cited the example of the Brazilian constitutional court, which was sinking, drowning under a flood of applications coming in. And they simply decided unilaterally, without any legislative text, that they would only deal with cases which, in their view, raised an arguable issue. That they themselves brought in this criterion. So it's I think, a general point. The citizens now are more aware of their fundamental rights and more willing to go to courts to claim their fundamental rights. And there are many more civil society is growing stronger. There are many more non-governmental organizations